Cohen. We have about over 100 people who've already signed in. We have in excess of, well, almost 400 people who are scheduled to join the uh, presentation today. And this is actually the third time that I've done this presentation. I did it approximately a month ago, 5 or 6 weeks ago, and then there was so much demand for it that I did it a week later. And now there's been continuing demand for this topic. And at the same time, even between the first time that I did this presentation and the second time a week later, there had been significant changes in what's happening at the federal level. And now a month has passed and there's much more happening at the federal level, and there will continue to be. So I actually anticipate that I'm going to be doing this presentation periodically, at least over the next few months and possibly over the next several years. And this topic is relating to the changes that have arisen from the combination of the fact that Donald Trump was elected as president, that the Congress is now controlled on both the House and Senate side by the Republican Party, with the people in Congress generally appearing to be substantially willing to follow and endorse what President Trump is doing rather than to um, push back against it or vote against it. And as an outgrowth of President Trump's first term, and in very importantly, we now have both many judges who've been appointed by President Trump and have ideological symmetry with him to some degree. And most importantly, as I think everybody is aware, the United States Supreme Court now has a 6-3 conservative majority, three of the justices being justices appointed by President Trump and who have been, by their behavior, indicating a willingness to not entirely, but substantially grant President Trump many of the powers that he is seeking or taking, whether he's been granted them or not. So uh, there's a very, very profound change in the um, orientation to government at the level of the executive branch and the congressional um, idea of separation of powers, both between the House and Senate and between the Congress, uh, the presidency, and the court. And so there is an enormous degree of concentration of power coupled with an enormous degree of hostility to many of the functions of the federal government historically, many of the ways that federal money is being spent, and many of the laws and regulations that have been adopted over many, many years by the Congress, both Republicans and Democrats, uh, in many, many different areas, but particularly in the area of disability rights and special education, which is the focus of this presentation. And as the lead slide indicates, it's really as if there's a fire that's out of control in terms of what's happening in Washington, and to some degree, a sense that there's an effort to literally burn down the role of the federal government. And what I'm going to be doing today is going through both a very brief presentation of what some of the key laws are that relate to children with disabilities and that are at risk in relation to how they're being understood, implemented, and funded at the federal level as a result of the changes in administration, what the potential threats are that haven't yet been implemented, but what uh, may be implemented, though initially I'm also going to go through some profound changes that have already been implemented. And then I'm going to be talking about what can be done to try to respond to these changes. And I'm going to deal with that in a number of different ways. And I should say also at the outset, and there are now, uh, I think, about 150 people online at least. Uh, I was really pleased at the last two presentations, and I'm continuing to be pleased with the current one, that we've got a wide range of people participating in these, parents, advocates, lawyers who represent kids with disabilities, even lawyers who represent school districts, private clinicians, and then many people from public education, general and special educators, related service personnel, and uh, folks who are coming from universities, and even people who are coming from hospitals that serve children. I know there's a nice contingent of people here from Lurie Children's Hospital in Chicago. So that is a very encouraging thing. And one of the things that I hope will be clear as I go through this presentation to say at the outset is that while, and in my professional activity, there is often a a sense of conflict between parents, advocates, clinicians, and the schools. In relation to this issue, uh, there are many points of common ground. I think it's safe to say that parents and educators all have an interest in ensuring that the rights of kids with disabilities continue to be served, that funding remains appropriate and adequate, though actually, arguably, it should be more than it is, and that services and safeguards are maintained, if not enhanced, but certainly at the moment we're focusing on maintained in order to assure that kids in special education and indeed kids in education overall are able to continue to receive adequate and appropriate education. So there's a confluence of interest, and one of the themes of today's presentation is to encourage all parties, all potential constituencies to both be understanding and sympathetic to the very difficult position that all of these different interest groups are in. I would say at the very top of the list, parents who are scared about what's going to happen in relation to their children with disabilities. But everybody has a basis to be scared and to try to find common ground in both making it work at the local level and finding ways to advocate for maintaining safeguards and protections at the federal and state level. So there's a lot of shared interest, and I'm very much encouraged by the number of educators and clinicians who are participating in the seminar. So thank you for that at the outset. Uh, on this initial slide, there is some introductory information about how you can reach me. This is going to be posted on our website within the next week, so people can access it on the website. I only ask if it's going to be republished that it be done by checking with me first. I'm happy to support it being republished, but I do want to be given notice and the opportunity to make that choice. And I do ask that it be, if it's being republished, that it identify that I'm the author so that there's no question about where it comes from. And I would say, by the way, that I one even has to wonder at the moment as to whether it's safe to make these sorts of presentations or even participate in these sorts of presentations. And my response to that is that we all need to stand up for the rights of kids with disabilities, for all the rights of all children, and for the rights of all of us as members of this country, whether we're citizens or not, actually. So I don't believe that silence is in any way effective. And indeed, I would see it as a duty for all of us as citizens and as humans to try to make sure that the country remains as a democratic country committed to equality, justice, fairness, and meaningful and appropriate support from the federal government. I'm going to have to do this a little differently. Okay. Uh, this is a little bit unusual for me because I do lots of presentations. I don't typically start out with an in-depth review of my own experience, but because this is such a sensitive and intensely important topic, and there's interest from a whole lot of different people from different settings, some of whom I know very well, and many of whom we've never met, and you may have no knowledge of me going back, is to just take a moment to review my background so you have a sense that I'm not just speaking about this because I'm having nightmares about it, but I'm speaking about it based on substantial experience in both working as a lawyer and an advocate for kids with disabilities, but also at the policy level and influencing legislation at both the federal and state levels. So just a couple of things to review. I've been involved in securing multiple amendments to the Individuals with Disabilities Education Act, statutes and regulations, and probably one of my most significant things that I'm proud about at the federal level was I was very involved in the inclusion of attention deficit hyperactivity disorder in the other health impaired category of the IDEA regulations when that finally occurred in 2006. I've been involved in a number of successful efforts to amend the Illinois School Code and other state laws, including an effort to completely revise the hearing system under the special education law to change the way it operated, to make it more fair and with higher quality standards. I'm the co-founder and board member of the National Council of Parent Attorneys and Advocates organization, or COPA. You'll hear me make a couple of references to that. And I'm currently involved actually in, we started 2 years ago, and we're now expanding efforts to provide training to advocates in states all over the US to help them with doing state level advocacy to promote policies that protect kids and adults with disabilities at the state level. I'm also the former president of the National Children and Adults with Attention Deficit Hyperactivity Disorder Organization, or CHADD, many of you have heard of, and I'm currently on their public policy committee. I've been involved in several national efforts to push back against attacks on rights and funding, and I'm currently involved in several efforts to do that. And I'm the author of a book on special education called A Guide to Special Education Advocacy: What Parents, Clinicians, and Advocates Need to Know. And then finally, and ultimately, most importantly for me, I'm the parents of 2 adult children, one of whom has multiple disabilities and went through special ed and required advocacy in order to get his needs met. I want to start out with, as I said, just a very brief review of what laws are most important for kids with disabilities. But before I do that, I should say I have opened up the Q&A for those of you who are joining, but I'll not be answering questions until I'm done. There's just so much to talk about that I want to try to get through it. That's a little different than how I usually present, but I will be happy to take questions at the end. If people want to send me an email, I'm happy to respond to emails after the fact. And if folks have comments or additions or suggestions to make after the webinar is done, I'd be happy to get those as well, including ideas about additional strategies for how you can make sure that your child and the system as a whole is ensuring the rights and services for kids with disabilities. So I'd love to have that feedback, so please provide it. What laws are most important? The one that we're going to be focused on to the greatest extent is the IDEA, the Individuals with Disabilities Education Act, which is a funding statute that has strings attached. In other words, the federal government provides substantial money to the states, and in return for getting that money, the states have to agree to abide by the rules or the laws that are the details of what has to be done that are contained in the IDEA. The IDEA, if you imagine it as a skeleton of law, then the U.S. Department of Education adopts regulations and issues interpretations which give additional definition and meaning to what the law says. And I mentioned in my introduction that I was involved in helping to get ADHD included into the IDEA. That effort was done under the other health impaired category in the regulation. The statute wasn't changed. So that's an example where the U.S. Department of Education, by regulation, expanded the scope of who was covered under the IDEA without there needing to be an actual amendment to the federal statute. The IDEA funding is contingent on congressional appropriation from year to year and provides categorical funding, which means that the states and districts receiving the money have to use the money in the particular areas where it's intended to be spent and have to agree to provide the programs and rights that go with the federal law that have to be implemented because you're taking the money. The IDEA also importantly contains funding for research, innovation, technical assistance to states and schools, and even provides training. And I see there are a number of parent training and information centers on the call. It provides federal funding for many organizations, in some of them multiple organizations in particular states, that provide information and support to parents. So the IDEA has many different ways that it supports special education and supports educators and parents. Section 504 is a very short law that basically says it's illegal to discriminate on the basis of disability in any program or activity that receives federal financial assistance. That's the law. It's one paragraph long, in contrast to the IDEA, which is many, many, many pages long. The IDEA regulations obviously are important, but in relation to Section 504, the regulations are critical because the 504 law itself is so brief. So there are somewhat detailed regulations that say that public schools and any other entity that's receiving federal financial assistance have to provide reasonable accommodations, have to provide evaluations, have to provide related services, have to provide extended time on tests, preferential seating, special procedural safeguards if a child is having behavioral difficulties, and so on. The Section 504 and its regulations are enforced by the U.S. Department of Education Office for Civil Rights, and they also issue interpretations where they say, we think that here are the things that reflect how schools should be providing 504 support for kids with this disability or that disability. Here's how they should be handling discipline situations and so on. The 504 statute doesn't provide any funding, but it's enforced by OCR, Office for Civil Rights, and as I'll be talking about later, the Office for Civil Rights itself is being decimated by virtue of the changes in Washington. The 504 regulations are also at risk. So 504 among the federal laws is particularly in the microscope at the moment in terms of being potentially scaled back or even curtailed in terms of the ability to be a key legal protection for kids with disabilities. The Americans with Disabilities Act is actually covering some of the same things that the Section 504 statute does, but in contrast to Section 504, which has very little content in the statute, the Americans with Disabilities Act is quite a bit broader and more detailed than the Section 504 regulations, but because it was adopted many, many years later than Section 504, the public schools and the advocacy community tends to focus more on Section 504 and not pay as much attention to the ADA, but it's important to be aware that both of those laws apply to public education, and significantly, the ADA also applies to private schools as long as those private schools are not religiously controlled. By contrast, Section 504 only applies to schools that receive federal financial assistance, which might include religious schools, though typically it doesn't, but doesn't typically include the private school community. ADA is enforced by the U.S. Department of Justice. Diminished enforcement through Department of Justice is likely, given what's happening with funding, reduced staffing, and the push to shift priorities. And it's going to be especially difficult to get enforcement in relation to private schools. The regulations under ADA may also be at risk in relation to efforts by the so-called Department of Government Efficiency and the courts, and I'll have more to say about that as I'm going through the presentation as well. It's important to recognize, as may be obvious, but laws can change, and they can change in dramatic ways, and I just want to comment for a minute about some of the ways laws can change. First of all, Congress can amend a law, adopt a law, repeal a law, or amend a law from year to year. Some statutes are set up to be time limited or to what it's called sunset, so that they expire after a certain period of time unless they're reenacted. Funding can be increased or decreased from year to year, and agency regulations and interpretations can change from year to year. Equally importantly, and I'll be talking about this as well, court interpretations can change over time. And we've seen in just really the last year and a half, and now even more so in just the last 3 months, the U.S. Supreme Court itself adopting many, many dramatic changes from existing Supreme Court precedent and really changing how we understand specific statutes and related to the overall situation and what's being done by the Trump administration, basically giving the administration not a complete free pass, but substantial latitude and discretion to do what it wants without adhering to the rules that are included in statutes and even the requirements that are included in the U.S. Supreme Court, in the U.S. Constitution. An example of that would be that the 14th Amendment includes an explicit right to U.S. citizenship if you're born in the United States, regardless of the parentage or citizenship of your parent. And the Trump administration has announced that it's not going to follow that requirement, and that's being litigated right now. Currently, that position has been paused, but we don't know whether the Supreme Court will ultimately side with the uh, historical understanding that the 14th Amendment protected birthright citizenship, or say that the Trump administration has the right to change that and to decide that birthright citizenship will no longer be available. Uh, Another example of that, by the way, would be the administration recently said that were considering not just deporting non-citizens, but even deporting citizens from the United States because of some feeling that they may have committed a crime of whatever sort. The Constitution is ultimately the most important law, and it's the thing that guides all statutes. Statutes have to be consistent with the Constitution. It's what's supposed to be honored and followed by the president and the executive branch, and it's supposed to be interpreted and implemented and followed by the court system, ultimately with the U.S. Supreme Court being the final arbiter of how the U.S. Constitution should be interpreted. Importantly, the two core principles of the 14th Amendment that are relevant to all civil rights are the right to equal protection of law, which means you can't treat one group differently than you treat other groups, and the right to due process of law, which means that you can't take away a person's rights without having a court hearing and specific rules that give them an opportunity to be heard, have a lawyer, et cetera, in order to have a neutral party decide whether the action being taken by the government is acceptable or not. As I already kind of indicated, the laws are interpreted differently depending on which court it is, and as the membership of the courts change, the basis for individual statutes to have authority is that either they aren't being challenged and therefore there doesn't need to be court review, or they're challenged in court and the courts say, yeah, this statute is appropriate. Yeah, this regulation is appropriate. Or conversely, that these laws are inconsistent with the Constitution and they're struck down. Again, historically, prior precedent was a very important part of the understanding of the Constitution, though even prior to this current court, I would say in fairness that there are things that have been done by the Supreme Court that represented changes. For example, the decision to recognize the woman's right to privacy in terms of their personal decisions about having abortions and more broadly healthcare, which was first enacted through Roe v. Wade and the related cases, and then was recently rescinded by the current Supreme Court. So there's nothing in the U.S. Constitution that explicitly refers either to the fact that women have those rights or that they shouldn't have those rights. It's just the Supreme Court deciding to read something into it. What has actually happened? And I've gotten reaction from some people, and maybe this is a early warning, if you will, for those who might be unhappy about this. I've gotten reaction from people who say, why are you being so negative? Why are you being so pessimistic? Why are you assuming the worst about what's happening? I even had one comment, by the way, most of the comments are very appreciative, but I had one comment that said that I was fear mongering. And I want to be very clear. That's not accidental. That's not something that's done without thought. I think it's important for all of us to realize this isn't just talk. These things are happening. We don't know everything that's happening. We don't know everything that's planned. We know things that are being considered, but many things have already happened that are a result of the President Trump being elected, the Congress going fully to being a Republican-controlled Congress, and the Supreme Court being controlled by the conservative bloc. So just examples of this that are not education related, but there's been a halt of most federal foreign aid, termination of thousands of USAID employees, and termination of many people in the State Department. There's termination of thousands at the Centers for Disease Control, the IRS, the Environmental Protection Agency, and other agencies. There have been undetermined hundreds of thousands of individuals already terminated or moved into early retirement across the government. Initially, it was identified based on having some involvement with diversity, equity, and inclusion roles, but more broadly, people are being dismissed based on mostly unsupported allegations of inefficiency or corruption. Entire departments are being closed. Uh, Folks might have just heard that recently happened with the National Institutes of Health and the Center for Disease Control, where many important departments were just being eliminated. An example of that, which is especially frightening at the moment, is that some of the health departments that were within NIH and CDC that relate to monitoring and developing screening and treatment for infectious diseases like measles are being defunded, resulting in there being diminished or no federal response to coordinate and provide support to treat people who've already caught measles and provide vaccines for people who haven't been inoculated. And as a result, as we know, measles is suddenly breaking out, particularly in the Southwest, in ways that haven't happened for many dozens of years. Thousands of undocumented people have been arrested, even people with documentation, but who don't yet have citizenship. And there's even indication of people who might have had citizenship who've been arrested. 18 inspectors general for different departments in the federal government have been fired. That seems innocuous, but the inspectors general are the positions that are supposed to operate independently and with autonomy, that are intended to keep the federal departments honest, to make sure that they're protecting against fraud, abuse, and waste. And it's ironic that with all the concerns about government efficiency and allegations of corruption, that one of the first groups of people that were terminated was the people whose job it is to protect against exactly that sort of thing. And then a very important thing that's happening is that there have been many senior people and even line staff at the U.S. Department of Justice who have been terminated or who concluded that they needed to resign because they were asked to be doing things that were unsupportable. And I mention that because it's particularly important, because in all of this controversy about what is the administration doing and is it legal and who should be doing the things that the federal government is saying they don't want to do, or who should be doing things that the federal government is actually taking away from rights, like legislating that schools can't serve kids who have trans in terms of providing any accommodations if you're trans. Those things are normally implemented by the U.S. Department of Justice when they're being litigated, and the Department of Justice historically was supposed to operate relatively independently from the rest of the executive branch, so that you didn't just get to call up the Department of Justice and say, we want to sue or we want to change our position on civil rights or whatever. They were supposed to act autonomously in their interpretation of the Constitution and laws. And as all of these people who have historically recognized the independence of the Department of Justice are being replaced, now we have people coming in who are more likely to adopt positions based on what the president wants and not based on what a neutral evaluation of the law requires. All right, so enough at the general level. My overall point in addressing that was simply to say a lot's already happened that we should be very concerned about, and I'm sure anyone in this audience would be likely to be able to add other things that have happened that I didn't put on the list. But I want to shift now and talk about what's been happening already in relation to education and the U.S. Department of Education. So as I'm sure everybody is aware, President Trump has indicated a desire to actually disband and eliminate the U.S. Department of Education. That's more complicated than he would like it to be, because the U.S. Department of Education was adopted or enacted by virtue of an act of Congress, and it technically would require an act of Congress to do away with the U.S. Department of Education. Importantly, very many aspects of the Individuals with Disabilities Education Act, the IDEA, are specifically assigned to the U.S. Department of Education for implementation. So if they do away with the Department of Ed, either implicitly or explicitly, there's a big question about what happens with the implementation of various parts of the IDEA that were supposed to be implemented by the U.S. Department of Education. As people should be aware, there's already been roughly a 50% reduction in the staff employed by the U.S. Department of Education, including many staff working in the Office for Civil Rights and people who were directly or indirectly connected to diversity, equity, and inclusion efforts, even people who just went to an assigned seminar about it. They didn't have to have that as a part of their active job responsibilities. And there is already a plan, which we'll talk about more, to reassign many, if not all, of the functions of the U.S. Department of Education to the Health and Human Services Department, which also has had a substantial reduction in staff and funding. There's been already a termination in over $800 million in education research and technical assistance grants alleging waste and fraud with no evidence. Those are the grants that help to develop new educational programs that help to evaluate curricula and what's effective and what's working, that help to promote teacher training, that help to develop novel new programs that may be effective and ensure that the needs of particular populations are met. Things like developing specific strategies for children who have behavior, specific strategies for supporting children who've experienced trauma, particular strategies for responding to the problems that developed during the COVID pandemic. These are all things that are supported by U.S. Department of Education funding and research and technical assistance support. It includes funding for things like improving math instruction for kids who are struggling since the pandemic. It also cut funding for a very, very important federal program called the What Works Clearinghouse, which provided information accessible to parents and educators on what programs and curricula that would be available for schools to use, have a research base to say that they're effective, and which programs and curricula have little or no research base to say that they're effective, with the goal being, as is required in the IDEA currently, that that special ed programs be research based to the extent practicable. Importantly, in February 14th, 2025, Dear Colleague letter issued by the new Office for Civil Rights, it threatens termination of federal funds to any elementary, secondary, or post-secondary school that continues to engage in diversity, equity, and inclusion activities. That's a highly problematic threat if it's implemented, and even if it's not implemented, it will have a huge chilling effect on public education. One can see what's happening already with the way that the administration is pursuing higher education. Universities, Columbia, and a number of other universities agreed to make massive changes in their policies, and even to consider putting specific departments that dealt with African history and Middle East studies under some sort of federal supervision. It's basically censorship, and we just heard that Harvard and some other universities are now saying, sorry, we're not going to cooperate. That's a violation of our constitutional rights, and it's a violation of free speech, and it's an inappropriate role for the federal government to be involved in. Most recently, because I sort of constantly updating, the NAACP Legal Defense Fund just filed a lawsuit just this week to block the implementation of the Dear Colleague letter. That lawsuit hasn't resulted in a judicial ruling, but it's a very problematic change. There's also been reallocation of Office for Civil Rights priorities. They've actually closed multiple offices, including in Chicago. So those staffs have been let go altogether, with the promise that complaints would be redirected to the other remaining offices, but they've also fired many of the staff who were working for the Office for Civil Rights nationally. So the offices that remain have now much broader areas that they have to cover, with fewer staff available to cover them. So purely from a time and staff resource standpoint, that by itself will lead to a substantial reduction in the ability of the Office for Civil Rights to adequately receive, process, and decide complaints based on violations of Section 504 and other civil rights laws, and will mean that many individual complainants either will have to wait ages and ages or have no response to their complaint at all. In addition to that, the government has already announced that they're going to deprioritize Title VI, Title IX, and initially it looked like 504 investigations. Then there was an outcry against the elimination of such investigations on disability, so that, oh yeah, we'll still do disability, but in fact, our priority is going to still be, it's going to be on investigating anti-Semitism. Nothing wrong with that, but there are many other priorities. It's going to be on investigating issues of schools continuing to implement DEI, which they argue is discriminatory towards majority students, and to address issues of policies that try to provide access to students who are trans, particularly and including athletics. And then they've also even talked about that they're going to prioritize investigating words like inclusion and social emotional learning, which are core concepts in the educational community for how schools function, develop curricula, and indeed the goals that they try to set for developing broad and well-educated, well-rounded students to become contributing members of society and be productive citizens. There's already been freezes on federal funding and contracts in terms of education and in many other areas. And there has been a freeze on Medicaid grants that has resulted in some blocks of Medicaid at the state level. That's been paused by the courts, but even though it was paused, there seems to be continuing concern that the money is not coming through. That's relevant for education, by the way, because many school districts, if not all school districts, collect a substantial amount of money from the federal government to underwrite the cost of related services like speech therapy and social work services, occupational therapy. So that has a direct impact on the schools. Be aware that court decisions that say we're going to stop the federal government from making these changes doesn't mean that they're going to be permanently enjoined from making the changes. The fact that they do it temporarily, there then has to be litigation and a fight and ultimately a decision, and then appeals to the appellate courts and Supreme Court to determine whether the freeze is temporary or permanent. And there are now growing indicators on a variety of different levels that the Trump administration is basically saying, we don't really care what the courts are saying. We're going to go ahead and implement these things anyway. And that's leading to increasing conversation about a constitutional crisis where courts may be saying the federal government can't do something. And in the past, that would be generally binding. And then the current administration saying, we don't really care. What are you going to do about it? And the courts having very limited power to make ways to enforce that. Sorry, just one more point for those in Illinois. There very quickly, there was approximately $1.8 billion in Medicaid funding that was frozen by the federal government. So these things can have a very immediate impact on all of the states and school districts. And then there's another thing that I want to mention that's already happened that poses a big risk to civil rights, special education rights, 504 rights, your right to clean air and water, and many, many other things. And that's a Supreme Court decision that was issued recently called the Loper, L-O-P-E-R case, that overturned a prior decision that said, generally speaking, the courts are required to give deference to regulations and interpretations that are made by the federal departments that are implementing federal statutes, federal laws. And so, generally speaking, the departments were allowed to adopt regulations which gave additional meaning, just as I've already given examples in terms of the special education regulations that go beyond the specific language of the statute. And the Loper case basically said that you don't have deference automatically given to the agency or department, that there has to be a very explicit and specific delegation of that particular duty or task to the executive branch, to the department that's charged with implementation. And that may lead to all sorts of regulations being challenged, and there are court cases that have already been filed to do that. And it may, for example, give rise to an attack on the designation of ADHD and Tourette syndrome under the IDEA, other health impaired category, which is done through regulation rather than through statute. There's also a court case that's pending now that many of you have heard about called the Becerra case, which was brought by the state of Texas and 16 other states to challenge the addition of gender dysphoria to the 504 regulations because it wasn't contained in the statute, and that case is pending. So lots of changes that are potentially occurring based on a court decision that's already been made that undermines the authority of federal regulations. Even more frightening, but consistent with the point that I made earlier, that the Trump administration appears to be saying they're just going to take whatever room they have and run with it. Just in the last couple of days, the administration announced that they are going to be unilaterally removing regulations issued by 400 federal agencies based on the Loper decision. I haven't seen, at least if someone else has heard of this, they please email me. I haven't seen anything that specifically targets the U.S. Department of Education, let alone the 504 and special education regulations, but there may be a much more detailed announcement coming out just in the next few days that may indicate which regulations are going to be changed or eliminated, and that may include 504 and IDEA regulations. So this is very worrisome. And that graphic, by the way, is intended to illustrate laws being ripped through the middle, being torn up. That's what's happening. So I've already actually talked about Becerra, so we can skip that. The result of pressure from the disability community did lead the attorneys general from some of those states to say, oh no, we didn't mean for the Becerra case to be targeted to disability rights at all. It was just about gender dysphoria. But even though they said that in public statements, they haven't actually changed the lawsuit that's pending in court to make that correction. And we also have to be aware that the judge could make that decision even if they say publicly that that's not what they intended. All right, so it's pretty apparent that there are a lot of things that have already happened, but we don't know everything that's being proposed. We don't even know everything that's being considered that hasn't been proposed, and so there are many questions about what may come next. From my perspective, where there's smoke, there's fire. Well, in this situation, it's already worse. There is already a raging fire. The only question is whether the fire is going to spread far beyond what's already been done. And I think that the answer to that, sadly, is yes. In fact, what's happening is historical guardrails and checks and balances are no longer there. The executive branch is asserting sweeping executive power, including termination of funds, firing personnel, shutting down departments and agencies. The legislative branch, controlled by the Republican Party, has shown no readiness to reject or even disagree with the administration on legislation or nominees. The good news is there's at least one small example where it happened, that they did just defeat by 3 votes a bill in Congress to limit the rights of trans individuals. The courts are issuing orders blocking Trump's actions in some instances, though not all courts have decided to do that. The Supreme Court has, in a very few cases, limited what the Trump administration has been doing, but in most cases has been adopting the position that the Trump administration has been taking. And most importantly, as I hope folks remember, the Supreme Court just a few months ago granted President Trump, or all presidents actually, blanket immunity for all actions taken as president, which basically means that there's no legal accountability for the president doing something that's contrary to law or contrary to the courts, because they're given immunity, which means there's essentially no ability to prosecute them for wrongdoing, other than potential impeachment, which is unlikely at the moment. Why don't we know everything that's going on? Many things are being discussed or proposed but haven't been implemented. Some of the things being implemented have been blocked, and we don't know if those blockages will be made permanent or not. And it's unclear if the administration will honor court decisions, even if the injunctions blocking the administrative actions are issued. So lots of problematic things happening. So now I'd like to change focus and highlight some of the top risks to special education and disability rights. The first is that the U.S. Department of Education will be disbanded and its functions moved to the Department of Health and Human Services, or simply dropped from federal functioning altogether. There are many different programs that are under the U.S. Department of Education, so we don't know where all of them are going to go. But even a program that's not special ed specific, which is the provision of financial aid to college and university students, that is a huge part of the U.S. Department of Education that's being moved to the Department of Health and Human Services. Their staff has been reduced. So it was highly backed up and problematic at the U.S. Department of Education. It's going to be moved to HHS, and they have even left less personnel and capacity to administer the program than was true in the U.S. Department of Education. It's going to be a big nightmare. Many other functions of the U.S. Department of Education may be lost. There's going to be a likely loss of even more staff with educational expertise and institutional history. There's no discussion so far of U.S. Department of Education staff being moved over to HHS staff. As I indicated, the staff at HHS is also being reduced and will be unlikely to manage the DOE workload. Secretary Kennedy is also on record for many, many years questioning the legitimacy and asserting the overdiagnosis of many disabilities, including autism, ADHD, and many other psychiatric disorders. At the risk of putting it crudely, having the eligibility and rights of kids with disabilities for special education and 504 protection put under the Department of Health and Human Services under his control is quite explicitly having the fox guard the chicken coop. And it seems very, very concerning as to what their position will be on the rights of a whole variety of disabilities. Some of you may have also heard recently he had made quoted as making very offensive comments about the rights of and functioning of kids with disabilities generally, and essentially was articulating a kind of a feeling of they should be not given the right to participate fully in the activities that would be open to other people because they don't really have the ability to take advantage of them. He's generally unsupportive of the inclusion of people with disabilities, and in the context of mental health, ADHD, substance abuse, and other things, he actually proposed it might be better to just send kids who are having those problems to training camps out in rural areas where they could be indoctrinated in ways and engaged with growing organic foods and eating healthy things as a way of basically curing their disability. Obviously, not based on research and contrary to what many, many families and professionals would see as in any way appropriate. So the doing away with the Department of Ed, hugely problematic. There is a huge push from the federal government to reduce funding for public education generally and special education specifically, due to both reduced overall federal financial support and in plans to shift the money that the federal government provides to block grants rather than categorical grants, which means basically instead of giving the money to the states and saying, here's how you have to spend it, they would just give the money to the states and say, you get to decide, which removes many, many of the controls, safeguards, orientation to modern and best practice, and procedural safeguards and other things that are currently provided by the funding that's delivered by the federal government to the states. There is also, through an executive order the president signed, a desire to repurpose federal money, potentially including IDEA funds, into school vouchers, which would be managed at the state level. And there's also been a federal school voucher bill that's been introduced in the House. It's a tax credit, so that may be coming out as part of the overall financial budgeting efforts that the Congress is making, but it hasn't been adopted yet. But the changes in federal funding and the move to vouchers is highly problematic. Money for block grants may strip away the federal mandates, as I mentioned. The block grants will also allow states to prioritize how the money is allocated, which may mean good things in some states, but may mean building a lot more football fields in other states rather than things that kids actually need. Money for vouchers will likely reduce funding for public schools, and that may be true of the block grants as well. I know that many people and many parents in the disability community, as well as in the community at large, think, well, we're frustrated with the way that public education is working. Vouchers will help us to get our kid into a private school, and so they feel that vouchers may be a good idea. But that's based on a wishful thinking type of approach in my mind. Private schools are under far less legal obligations, less specific legal obligations to meet the needs of kids with disabilities, indeed less specific obligations to even accept kids with disabilities. So it's not at all clear that having a voucher, if you're a parent of a child with a disability, is going to be particularly helpful in getting you access to a school that will serve your child with a disability. Private schools are often less equipped to provide special education and less willing to provide accommodations. And then people don't think about this, but many communities don't even have access to quality private schools. And in poor and rural areas, there may be few or no private schools at all, let alone enough spaces to serve all the kids who may want to go. And then in tandem with that, because they are likely to be taking some of the money to pay for vouchers away from the public schools, what is probably going to be left is an even higher concentration of kids with disabilities in the public schools. We recognize, no dispute from anybody, that kids with disabilities typically require more funding in order to provide the programming that they need. So the public schools are going to have more kids with special needs with less money to meet their needs, let alone that that's not going to be as representative of the community and diversity and inclusiveness, including access to typical peers and so on and so on. So I would just note that these changes in federal funding that are in the works are threatening to public education generally and highly threatening for kids with disabilities. Fourth risk is that there will be further reductions in staff at OCR and the Department of Justice, which, even if the laws continue to provide a basis for enforcement of rights under 504 and other civil rights laws, if there are no people there to do it, or not enough people there to do it, it's not going to happen, folks. It's just not going to happen. And indeed, we're already having clients who filed complaints that they're being told their complaint isn't going to be processed because there's just no availability of people to do it. So this is not just going to have a chilling effect, it's actually resulting in the virtual elimination of access to these federal enforcement agencies to provide meaningful access to individuals filing complaints. And notably, and very problematically, historically, an individual could file a complaint with the Office for Civil Rights or the U.S. Department of Justice. As a parent, you didn't need a lawyer to do that. There might have been times when having a lawyer help might have been useful, but it's a free process. You file the complaint, and then they take over the investigation. So the dramatically reduced access to these things has a potentially crippling effect on the ability of parents to get redress if they feel that their child's rights are being violated. The curtailment of federal regulations and OCR and OSEP is the Office of Special Ed Programs interpretations may mean substantial reductions in rights, substantial reductions in program obligations, and reductions in research and development of best practices. So there's going to be a widespread potential degradation of the means of ensuring rights and the means of ensuring the development and adoption of best practices into educational programming at the state and local level. Sixth risk is the potential reduction in eligibility categories, particularly ADHD and Tourette syndrome. And we may have to be suspicious about autism because we know that Secretary Kennedy has a strong bias about the diagnosis of autism. So there's a concern about the broader regulations being challenged, but also just about who's eligible to be recognized as a person with disability under IDEA 504 and ADA. So these things are all at risk. Seventh thing that I want to highlight is that both the IDEA and Section 504 provide very specific protections for kids with disabilities who are having behavioral problems, including a strong emphasis on the provision of positive behavioral interventions and supports as opposed to punitive interventions, and very specific procedures that are intended to provide due process before someone can be suspended, expelled, or forced into alternative placement. So those are all things that are going to be at risk as the federal government focuses more on punitive measures and exclusion and seems to have in its entire activity far less regard for the importance of due process of law in relation to any rights, as we see them sending people into detention or even sending them to jails in other countries when they previously would have had rights to go to a court hearing and get review before that could be done. Final risk that I've already mentioned, but want to just reiterate, is that there is a risk of Medicaid and even Social Security being cut or the procedures being tightened, which will have an effect on direct benefits that kids and young adults and all adults with disabilities receive, but will also have an impact on the public schools to the extent that they may be less able to recover reimbursement for related services, which then will mean that they would have to find those dollars somewhere else at the same time that funding will be drying up from other quarters. So many, many risks. I've already talked about the problems with Secretary Kennedy's um, perspective on mental health conditions, also concerns about FDA drug approval process and allegations of overprescriptions of medication, which may affect kids with disabilities. Congress may cut Medicaid as indicated, and there may be impact on school funding. Another thing that's concerning is that the more that we decentralize funding without standards and statutes, the more that what you're entitled to is going to vary by the luck of the draw in what state you're in. So some states like Illinois may continue to have strong rights for various things, and you could cross the border and go 50 miles over, across one river and another in Indiana or Iowa, and those states provide far less protection. So again, many people on this call from around the country, the whole part of the point of the federal government is to ensure basic floors of rights and basic floors of services in areas that are needed that protect against those individual variations and even protect against some of the uh, disparities in wealth among the different states to ensure that, again, that there's some basic ability to meet needs regardless of what state you're in, and that's going to be at risk. So many rights and programs are at risk. And again, people might say they can't be serious. Most of this is just talk, right? It's not really going to happen. We've already seen the worst of it, and now it's going to be okay. So I don't know if this graphic is clear, but this is an ostrich who is sticking his, her, or their head in the sand. So the idea that this isn't going to happen to us, that the president is just bluffing, that's just not correct. It's unwise. It's incorrect. It's wishful thinking to think that these things won't happen. Many of them already are, and there is strong momentum for many more to happen. However, some good news, advocacy can and does have an effect. The administration did announce that it was not going to apply some of the limitations on civil rights and civil rights enforcement in other areas to disability rights because of pushback. There are anecdotal reports that OCR is processing some disability complaints. As indicated earlier, the plaintiffs in the Becerra case did indicate that they weren't intending to target all 504 regulations. Many courts are issuing injunctions to stop some of the administration's actions, and there are growing reports of town hall meetings involving both primarily Republicans, but Democrats as well, where people are experiencing strong protests and saying, don't let them keep doing what they're doing. And on a very positive note, some states are already taking proactive steps to adopt at the state level some of the both protection and in some instances even funding that was previously emanating from the federal level. So that's something to think about and talk about. I'll be getting into that a little bit more as we go forward. What can you do about it for your individual child or student and for the state and systems that you work in? So I'm going to talk now about individual steps that parents, educators, and clinicians can take or advise others to take. I'm going to talk about school system steps, and I'm going to talk about legislative and political system steps to try to ensure the level of rights and protections and services that kids have now, even in wishful thinking, to enhance them, but also to push back at the policy level to make sure it's not happening to anybody. So I want to start out with talking about the things that people can do for a specific child. And by the way, it can be a child who is your own child. It can be a child who's your student. It can be a child who is your client. I think it's relevant to everybody. Starting premise is that information is power. And because there are many things that are possibly going to happen that are bad, but we're not sure exactly how they'll happen, when they're happening, or to what extent they're happening, information is even more important now than it would have been in the past. So the more information you can have, both about what's happening at the policy and legislative level, and the more information you can have about the specific child to make sure that decisions continue to be made on an informed basis, governed by what's legally required, the better. So I would argue that you should be doing a variety of things to enhance the degree of information gathering and sharing that's occurring by the parent, by the educators, by the professionals. And that is not just obtained but passed back and forth to ensure that there's a solid basis to support why a child needs what they need and why changes or reductions shouldn't occur. Parents and clinicians should periodically observe the child at school. Parents and their clinicians have a legal right to observe their child, not whenever they want for as much time as they want, but on a reasonable basis within reasonable limits by the school. And that can include not only the parent, but a psychologist, speech therapist, social worker, whatever, even an educational tutor. And I would argue for more communication between the private professionals and the school professionals in both directions to try to enhance understanding of what's going on. And by the way, that may also have, it might take a little bit more time in the short run, but to the extent that it enhances the quality of services and the reinforcement of services across settings, it may actually produce better outcomes and be more efficient in the long run. I would argue for both the parents to seek and the public school and private clinicians to support more frequent and more broad evaluations to make sure that all of the areas of need for a child are being adequately evaluated rather than just making assumptions about them. People probably are aware that a number of years ago, the federal law was changed to allow for what's called a records review if the parent and the school agreed to it, rather than having to do a full-blown reevaluation every 3 years. It's important for parents to be aware that you have a right to request the full-blown reevaluation, even if the school's recommending a records review. But I would suggest that for both parents and educators who are concerned about their students getting what they need, a more in-depth evaluation is desirable because the more data that you have to support need, the harder it's going to be to take things away. And then I would argue to parents and even private clinicians, volunteer at schools, make your presence felt, be in around at the lunchroom, go on field trips, help out in the classroom. The more that you can see about what's going on, the more likely you're going to be able to figure out either how well your child is doing, or conversely, that there are problems that you might not have realized or that you realize but that are not being appropriately addressed. And in addition, educators can benefit from having extra help. And to the extent that resources may be tightening, volunteers may become increasingly important in helping to ensure that the educators can spend their time on the important things rather than on things that could be taken over by volunteers. So there are many things that you can do at an individual level to get more information. In addition to that, very much important in both directions, parents and schools, try to build rapport and informal communications with school staff and parents and the private clinicians to the extent they're present. Convey that you value them and want them to be allies. Important for educators to show empathy and appreciation for the efforts of the parents and the difficulties and challenges they face. But equally important, parents, convey your appreciation for the school staff and empathy for the struggles they may have, and recognize that their jobs are likely to be getting more complicated as these changes go through. And we're aware that it's already a demanding job. So the more that you can convey appreciation and support, the better. Try to develop lines of communication with the administration, case managers, vice principals, principals, superintendents, even the boards of education. Network with other parents in your child's class. You may have a child who is either nonverbal or has difficulty communicating or simply doesn't share. The more information you can pick up from other people and provide them, the more everybody's going to be in a position to recognize that a change is occurring or a problem is present, and to be able to speak up and advocate to make sure that the child's needs are being met. Attend district parent groups, special ed PTA, PTO. There are many communities that have local support groups. If your community doesn't have one, good idea to set one up now. It's needed now more than ever. Go to school board meetings, listen, and take advantage of the parent participation segments to share concerns that you have. Preferably don't go alone, but develop connections with other parents so more and more of you are going, and so that the school board's aware that parents know what's going on and they're watching and they're monitoring and they intend to hold the school board accountable. Pick your battles, but mobilize when needed. Try to constantly assess how your child is doing, prioritize what is needed to assure that they are getting appropriately educated. Don't sweat the small stuff. I once had a client who was a professor of English at the university level, PhD English professor, who would get her child's IEP and she would get out a red pen and edit the spelling punctuation and grammar and send it back to the school staff filled with red corrections of their IEP. Well, that was in some ways a very powerful thing to do because she was understandably frustrated if the things that the school staff were writing were not using proper punctuation, spelling, or grammar. But imagine the reaction that that caused to the school staff that had nothing to do with whether the goals were appropriate or they were doing a good job with the child. That would just make them upset that this parent was giving them a hard time about something that didn't really matter to their child's education. Prioritize building relationships and collaboration with the staff and the parents and seek active communication. That's something that is in place in varying degrees between parents and schools, even in varying degrees within schools. The more everybody is promoting that, the better equipped everyone will be to problem solve if some of these changes occur. Watch for red flags. The district, here are examples of red flags. The district suddenly says that your child no longer needs some or any of the services that they currently receiving. The district comes up with a policy that says we will no longer provide X, or they change the cutoff point for eligibility, or they make other changes at a policy level, not an individual level, that have the result of denying eligibility or restricting services. The district suddenly expands or changes in-house programs that reduce options for services. The district changes the allocation of shared or one-to-one aids, or combines classes, shifting from individual to shared aids, or maybe even says, we're going to take 2 special education classes and merge them into one, dramatically increasing class size. The district shifts from direct service minutes to consult minutes, or from pull-out minutes to push-in minutes, or services. All of those things might be appropriate for a particular child. They might be done just for the purposes of spreading their staff more thinly and thereby saving more money, but with the potential degradation of the quality and quantity and intensity of service. Transportation may not be available or may take substantially longer for the typical ride. Class sizes may be increased, even including waivers from the state agency. And specialty contained classes may be contained with others that are larger. They may even do things like put classes of kindergartners in proximity to a class of high school students, or even students in a transition program who are 18 to 22. Things like this are all red flags that maybe have a legitimate justification programmatically, but often are being done for economic reasons and availability of staff. And they're not an automatic reason to say that there's something wrong, but they should be an automatic tip off that you need to be very careful that this is not causing either an illegal change in what your child was being given, or an inappropriate degradation of service, ostensibly for neutral reasons, but in fact just to save money. And it's important to recognize that cost legally is not a defense to not providing needed services. If the child requires something in order to benefit from their education, the school district is supposed to provide it. They don't have to provide the most expensive if there's a less expensive alternative, but they can't say they're just not going to do something because they don't have the money. If there are red flags or if things aren't going well, start with the direct line staff and work your way up the chain of command. Try to maintain positive relationships and collaboration as much as possible. Avoid raising competence, honesty, or personality issues at the IEP or other group meetings. Try to resolve it with the staff person individually if you can, and then with the supervisor in private if possible. It's been my experience that if you attack an individual staff person in a public context, the rest of the team, in almost all instances, is going to recoil, come to the aid and defense of that staff person, wonder about if they're going to be next, and also that the administrators are going to feel obligated to defend and protect that staff person. If you provide that information respectfully and privately, there's at least a greater potential that it may be solved, and a greater potential that if the problem is dealt with, it will be dealt with in a way that doesn't provoke even more conflict between the parent and the educational team. Consider going to the district administration if the issue isn't resolved at the team or school level, particularly if the problem is a district decision, and that can be as far up as the superintendent and the school board if needed. However, I want to be clear that while I'm advocating a careful and restrained approach to problem solving, if there is a sudden or dramatic change in services that's really potentially detrimental to your child, and I'll speak to this again in a minute, but there are mechanisms available, particularly a procedure called mediation and a procedure called a due process hearing, that can be brought by the parent or by the school to resolve disputes. And if that procedure is requested within 10 days of the change, then there's something called the stay put placement rule, which generally kicks in, which means that the change can't be implemented while that conflict is being worked out until it's finally resolved. So it's very important if a sudden change is going to be made that you follow those procedures and make sure that the stay put rule clicks in. We have a case like that right now where a child is being recommended for transfer to a therapeutic day school. The parent hasn't had time to investigate the parent day schools to make an informed decision. So we just requested mediation in order to give the parent the time because stay put prevented the change of placement while the mediation is pending. But in fact, I had a direct conversation with the school's lawyer before we even are having the mediation, and we agreed to the basic notion that because everyone agreed that a change of placement was needed, we would work on just opening up the options for where that would be and eliminating some options that the parent didn't want. So as much as you can, try to work it out informally, but make sure that you're triggering requests for mediation or due process if there's a time constraint. Avoid fights if possible, but know your rights. You have the right to participate in the IEP process, the right to voluntary mediation if it's requested by itself, to due process hearing, including mediation if you feel you need a due process request, and to file a complaint with the state education agency in Illinois. It's the Illinois State Board of Education, or theoretically, the right to file a complaint with the Office for Civil Rights for violation of Section 504, though if you're, the gist of what I'm saying is that the OCR complaint may not be all that meaningful at the moment as it might have been in the past. And again, remember the stay put placement clause. Timing is everything with the stay put placement clause. If the district has recommended a change in placement or service level, you must file within 10 days to trigger the stay put placement rule. So that's very important. And really, this is more of the same. If the district proposes the change, you can request mediation and or a due process hearing. You must file within 10 days. And the school can request an emergency hearing in situations where the child is posing a danger to themselves or others, or has brought drugs, alcohol, or illegal substances to school. But other than that, the school has to honor the stay put placement provision. In some states, including Illinois, if a parent requests mediation, that also triggers the stay put placement rule. There are some things that don't result in the stay put placement rule, like if the school just decides not to use the same goal, but any change that results in a change of eligibility, placement, or services, the stay put placement rule is applicable. And there are forms for requesting mediation and due process on your state's state education agency website, or should be. I think they should be on your school district's website as well, but in any event, your state will have them. District level actions that you can take include forming a parent advisory or support group, keeping local media informed about the issues and concerns. As I mentioned, attending board meetings, although it's highly mind-glazing, get familiar with the district's finances. In my experience, some school districts kind of tend to stigmatize the special ed program and blame kids with disabilities for budget challenges that the district is having. Number one, that's money well spent and it's a legal obligation. But number two, districts often don't provide the same explanation that the schools are also getting substantial state and to some degree federal reimbursement for the special ed services. So while they are disproportionately expensive, it's not as bad as just the expense side would make it appear. Get to know your school board members. They're your neighbors. They're legally accountable to you, and you want to have a relationship and share your concerns with them. Consider running for the school board yourself. It's a big job, but somebody has to do it. And support school referenda seeking increased funding. School referenda sometimes are controversial and for things that may not be necessary, but if the school district is saying that they need the extra money to either operate or to have a safe building, it's important for your child to support the referenda. It's also an important message to the school that you're aware of the needs of the school and you're working to make sure that the school has adequate funding. Things that you can do at the state level: get to know your state legislators, particularly those on the education committees, find allies, identify and join groups advocating for special ed and disability rights services at the state level. support funding increases and legislation supporting special education rights and services, partner with other parents and advocacy groups as much as possible. Partner as well with professional groups like the School Social Workers Association, the Principals Association, the Administrators Association, the speech therapists, and so on. All of those groups have an interest in special ed, and you ought to be able to work with them, especially on these issues. Consider contacting your state attorney general to urge them to either oppose the Becerra litigation threatening 504, or if they're in a state that's already been a plaintiff on Becerra, encouraging them to withdraw from the litigation and reject the litigation trying to undermine Section 504. Build current federal protections into state law. A number of states, including in Illinois, our advocacy and educational groups are considering, given that there's a risk to the continuing viability of federal statutes and federal laws protecting kids with disabilities and protecting programs, what can we build into the state laws that ensure that those rights will continue to be present and enforceable at the state level, even if they're no longer present or enforceable at the federal level? So that's another reason to think about state level advocacy. Is that something you can't do as an individual, but as a part of a group and working with other groups, you may be able to build in the state level protections so that what happens at the federal level isn't as important. Things you can do at the federal level. Contact your congressperson and senator regardless of party. Whether you live in a red state or a blue state, whether you're legislator, you're in a red district or a blue district, or especially in a swing district, they need to hear from you. And frankly, the Democrats need to hear from you as much as the Republicans, because all of the legislators are setting priorities for what they're going to push and what they're going to not push as much about. And you want special ed and disability services to be high on the list of things that your legislator is going to be committed to working on and to protecting. So regardless of where you live, having active communication with your legislator is important. The messages to the legislators should be: preserve the U.S. Department of Education, including OCR funding and enforcement for all civil rights violations, protect IDEA funding and mandates, protect 504 and regulations, protect Medicaid and Social Security, and oppose block grants and vouchers. One other thing I would suggest to people is, you live in your district, in your school district, in your legislative district, in your state, but you have friends and relatives all over the place who know you, who know your kids, who know your profession. Activate them, encourage them to make the same calls. The more people who are calling, the more impact it has. And even if you've got a legislator who's favorable, other people may live in an area that has a legislator who hasn't been supportive or who has just not taken a position one way or the other. For those who want to get slides, you can get this off the website later, but I've indicated 2 websites that will give you information based on where you live about who your legislators are and how you can contact them. It's very easy. It only takes a couple of minutes. And in fact, the 5 calls website will even, you can type in the issue that you're concerned about, and it will help you to identify points that you can use to stress in communication with the legislatures. Now, to be clear, most people aren't going to get to actually talk to the legislator. The next best thing is to talk to the staff member in that office who's responsible for education or disability rights. The next best thing is to talk to somebody live who's just answering the phone. But even just having someone record a message that says, protect the rights of kids with disabilities in special ed, that's just tallied on a tally sheet. They do pay attention to all those things. And the more that we flood them with concerns in these areas, the more likely they are to be forceful in protecting our rights. We need to overwhelm them with calls as much as possible. Loud voices can't be ignored. Your voice matters. Go to town hall meetings, mobilize family and friends, write letters to the editor, join and donate money to legal advocacy groups such as COPA, DREDF, the NAACP Legal Defense Fund, Lambda, Mexican American Legal Defense and Education Fund, and the ACLU. If you're a professional or an educator, your professional associations also have political and advocacy arms, providing extra support for them so they can be active and in support of these things. Highly important. Mobilize family and friends, be politically active, and vote. Very important to vote. And from my perspective, it's very important to get out when there are protests and meetings being called, get out and make your voice heard in those as well. DEI is becoming a lightning rod for all sorts of things in education that are being complained about by the government, and by the government, meaning the federal government, President Trump and others. Disability rights, to be clear, are civil rights. The focus may be on race and gender as areas of concern, but all areas where we're talking about the protection of rights of minorities or disenfranchised groups are entitled to be physically present, are entitled to equity, and are entitled to inclusion. And indeed, equity and inclusion are explicit parts of what have been the goals for kids with disabilities for decades, and are in fact not just goals at a philosophical level, but they're critical to the opportunity to gain meaningful networks and to have interactions that allow them to build skills, develop friendships, learn social relationships, develop normal interests, and so on and so forth. The anti-DE efforts are fundamentally based on protecting those in the majority from many others, and I would argue are intended to splinter all of the disability rights groups. Stand for civil rights for everyone. If others are being disenfranchised or excluded, it will likely happen for people with disabilities too. And I would indeed, right now, all sorts of things are happening claiming that anti-Semitism needs to be stopped, and therefore elementary, secondary education, and at the college and university level, that DEI efforts have to be terminated. This is a complete smokescreen and a phony sham to try to use something that ostensibly is important. Not ostensibly, it's real. We should fight against anti-Semitism too, but the claim that DEI is opposed to, it means that it's anti-Semitic, or that you can support people who are Jewish to the adverse of people who are not Jewish. All of those things are simply a way to split groups, and not to recognize that civil rights are rights for everybody, and they need to be equally available for everybody. So please don't get in the trap of saying, I'm going to fight for this disability or this area of disability and not for other groups. They're all interrelated, and if we don't fight for all groups, all of our rights are going to be at risk. A few closing thoughts, and then I'm going to open it up for questions. Try to make friends and make the school staff and parents your allies. Don't pick battles that you don't need to pick. Try to recognize the pressures that parents and educators are experiencing. As I indicated at the opening, try to express an appreciation for the commitment and effort. Try to form alliances among parents, professionals, and with the educators. We will all be more powerful if we are united. Know your rights. Be prepared to fight if you have to. Wherever possible, make love, not war. But sadly, at this point in time, more so than anywhere else, it's important to fight back if your child's rights or your system's rights are being compromised by virtue of arbitrary and illegal actions that have the effect of taking away rights, taking away money, taking away programs, and basically leading to the reduction in quality and access for all students and all people with differences. So with that, I encourage everybody, as I said, please provide me with feedback. If you have ideas, if you have information that might be relevant, please email me. Even though it's on the cover slide, my email address is matt@mattcohenassociates.com. I'd love to hear from you, and I will be doing more of these sessions as things continue to develop, and hope you'll join me for those. And for that matter, I'm open to doing them in other places if requested. So with that, it's all about the kids. And now I want to open it up for questions. So are there sample letters or templates of things to include when reaching out to legislators? I don't have them at the tip of my fingers, but a number of organizations have them. And if you go to the group that I mentioned that's on the PowerPoint for how do you reach legislators, they also have scripts that might be similar to templates. And a number of the advocacy groups are developing templates that are geared to this. So you have to find the groups that are most specific to your area of interest. Okay, other questions. Many schools restrict the opportunity to conduct observations. How can parents fight against those restrictions? The Supreme Court has said that part of what gives parents an equal footing in dealing with schools, given that the schools have the child all day and the parents have limited information, is the right to have observation. And the Supreme Court has said, and now state laws say, that you can observe on a reasonable basis with reasonable limitations, and independent consultants who are working with the child also have a right to observe under those circumstances. Okay, any other questions? What, if any, federal law can combat the potential of dismantling Head Start? Head Start is required to serve a 10% IEP population. There's no federal law that can protect it per se, other than the fact that it is federal law. So that's another, Head Start is something that's in the federal law, and that's something that should be something you speak up and fight about to say, hey, we continue to need it. Would there's a question from Pepe Silverman. Would the inclusion provided through special education be incorporated into DEI restrictions? Well, we're getting mixed messages about that. But one of the things that's happened that's really concerning and that suggests why this is potentially problematic is part of what seems to be accruing is that the federal government is saying, here are problematic words, and they're doing word searches and even using AI searches to identify areas that have problematic words. And guess what? Inclusion is one of the problematic words. So whether that makes its way into an explicit change in federal policy or simply calls attention to programs that promote inclusion that are for kids with disabilities, it's at risk. So I think that people need to recognize that. Can laws be amended by executive orders? They're not supposed to be. In question, in my work, we've had to apply heavy scrutiny to the languages we use about disparities as a result of executive orders on DEI, not only on race, but other things, rate disability. When communicating with schools to ensure our kids' rights are met, can you provide examples of language to avoid or include that might be easier for schools to approve such requests? Inclusion is participation with a range of peers. That would be an example. Instead of saying inclusion, say participation across settings with a range of peers. I even write that into goals sometimes, that you have to have the opportunity to communicate with peers with age-appropriate communication or academic skills in order to be able to develop the skill yourself. Have the appropriate ability to participate with other students who can model desired behavior. Someone asked, is 504 applicable to colleges, public and private? 504 is applicable to any public or private school that accepts federal money. Not all colleges accept federal money. So those that don't, 504 doesn't govern, but most public schools, well, all public schools are covered in elementary, secondary, and college, and most private colleges and universities accept federal money, so they would be covered. But for example, if it's a private religious school, they don't take federal money, they don't want to be regulated, then 504 would not be applicable. Someone asked, will slides be shared? Yes, they will be put on the website, hopefully within a week. All right, any additional questions? Will changes that work against DEI and children with disabilities affect the early intervention sector? They're going to affect all sectors. It may happen in different bursts. It may happen from different offices or departments, but it's going to be happening in many different areas. Has anything been defunded yet, or bills close to passing that will do so? Research and technical assistance has been defunded at the federal level to the tune of $880 million. So that's already happened. And recognize that when they fire staff, that's an indirect form of defunding. So they fired many of the staff in the Office for Civil Rights. That's a way of defunding what they're doing. Things are rapidly changing, but what are the best resources for parents to more effectively and accurately advocate for their child's needs? At the risk of being a commercial, I would say join support groups generally that are in your child's area of disability, and for a blanket support group that or advocacy group, it's focused on parents and people doing advocacy for parents, but the COPA organization has lots of things going on, both sharing information and to provide advocacy on all of these issues. Another question, do you know off the top of your head what Supreme Court case decisions discusses the ability uh, for parents and outside professionals to observe in schools? I think it's the Arlington School Committee decision. Another question, if you can't afford a lawyer who enforces laws for disabled children in the schools, if it's not ISB or OC, it's not ISB or OCR in my experience. Well, I think that's a very big concern. The law as it's currently written has both a governmental enforcement and a private enforcement right. You can always go to court yourself if you're not getting effective relief from the agencies. I wouldn't give up on ISBE or the state education agency enforcement, but that happens to be quite variable depending on what state you are living in and the position of the state government in terms of the willingness to actively get involved in enforcement. Someone wrote, special ed is eliminating triennial evaluation, just using what's in the case notes from 3 years earlier. That's called a paper review. Parents have the right to request that a full reevaluation be done. That's one of the things that's explicit in the IDEA. It's one of the few things where if a parent asks for full reevaluation at the 3-year level, the school has to do it. Does this create a basis for class actions? Well, it might, though a class action is very cumbersome and time consuming, but that is an example of something that could be a class action. Someone asked, will FERPA lose authority? For those of you who don't know, FERPA is the Federal Educational Rights and Privacy Act. FERPA has important regulations, but it doesn't really have very strong enforcement. So when you say loss of authority, there's no overt move yet that I'm aware of to eliminate FERPA. But as I've said, there's a risk to all of the regulations, and the FERPA regulations are very important in terms of understanding what the FERPA statute requires. And if those regulations are removed, that could have consequences. For anything that is lost during this administration, is there a plan to work to reinstate it or rebuild federal protections when things swing back? Well, that's an interesting question. Frankly, it's in some ways premature. I'm not sure we have the mental bandwidth, the people power, or anything else to do anything other than devote our time, energy, and resources 110% to protecting what's there right now. My level of concern goes to the fact that President Trump is repeatedly saying he may serve a third term. Regardless of President Trump, if the people who are supporting what Trump is advocating remain in power, President Trump may not be the president, but the policies may continue. So there's no assurance that this is just a 4-year or even better thinking, just a 2-year phenomenon if the Congress gets shaken up in the 2026 election. But so it might get better, but there's no certainty about that. I would say it's certainly likely that if these things are taken away, it's going to be many, many years to rebuild and replace what was in place. And as I think many people are aware, it's not that things were perfect. These laws and these programs all had many shortcomings. In an ideal world, we'd be fighting to improve the programs, not just to hold on to what is being in place right now. But there is such a huge threat to what's in place right now that we've got to put our attention to that, and then hopefully we'll be able to fight about everything else later on. Interestingly, the U.S. The National Education Association, which is one of the 2 major teachers associations or unions, if you will, has explicitly come out and opposed the elimination of the U.S. Department of Education. So that's an example of the potential for collaboration between the parent community and the educational community, which I would encourage everybody to engage in. As indicated, that's called an election. So I mentioned multiple times, vote, 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 get your friends and neighbors to vote, get your relatives to vote, and if some instances, run for office yourself. Okay, I think that's, let me just check if there are any final questions here. All right, I think I'll wait just another minute for any other new questions and then wrap it up. Oh, there's a question about whether the proposal to conduct a study of autism to try to come up with the actual cause of autism by September is good or bad? And do I have any thoughts about the adverse impact on Secretary Kennedy's opinions? Yeah, I think I already shared that, but I think it's extremely threatening. And I can't imagine a study that's convened uh, that has to be concluded by September, let alone a study by a government that's saying we're going to cut out all of the resources that we have now, so they're not even going to be available for a study, is going to be meaningful. Autism has been getting studied for years and years. We still have uncertainty about what causes it, but overall, I would say that the orientation of Secretary Kennedy is to question many, if not all, disabilities that are in the mental health arena, and to be highly critical and actually insulting to the rights and needs and humanity of all people with disabilities. And I don't know if everybody here what your political persuasions are, but disability is an area among the many other areas where people are subject to stigma, bullying, harassment, and insult. That is something that many of us try to oppose. And you'll remember that President Trump himself in the first administration actually publicly made fun of a journalist who had a disability that impacted his speech and his motor control, and mocked him publicly in front of the person, in front of thousands of other people. And so that's the attitude that I think is Secretary Kennedy is also communicating in relation to his attitude about disability. So all of these things need to be fought against, and we need to really lean heavily on our legislators to fight back. I don't think that an adequate job is being done at any level to push back against these changes. And so it matters to everybody. Maybe I'll conclude with one other thing. This is that I read an article recently that was an academician, a researcher. Remember that science is also an area that's being undermined and fought against by the current administration. But a researcher studied authoritarian governments in many different countries over many different years to see under what circumstances opposition groups were successful in getting rid of the authoritarian government and when they weren't. And one of the things that it said was that a critical variable was if 3%, only 3%, but if 3% of the public was engaged in opposition in whatever form, then they were ultimately successful in overthrowing the authoritarian government and producing a return to a democratic government. If less than 3% were engaged, then they were not successful. And what that says to me is that every single person who I talk to can make a difference. Every single person who's on this call can make a difference, and it will make a difference for all of you to engage and mobilize all the people you know to make your voice heard too. Doesn't matter in which ways. The more ways, the better, but protesting by phone call, protesting by letter, protesting by voting, protesting by demonstrating, protesting by meeting, protesting by donating money, all of these things, protesting by helping to support litigation. Every step that each of us takes, big or small, contributes to creating a critical mass of people who will insist on the protection of rights and ultimately the maintenance of a democracy that is at least generally in support of justice, equity, inclusion, and fairness. And I'm not in any way convinced that our society had all of those things to the extent that it should, but at least there were many efforts to promote it and to meet the needs of the public and to respect the will of the people in a way that still respected those who were in the minority. And that's the threat right now. So please take every step that you can, and together we'll make a difference. And I think that will be a basis for us to say good luck, and I hope we can all do it together. Again, please feel free to reach out to me at matt@mattcohenassociates.com if you have questions, if you have comments, if you have ideas, things to add to the presentation, additional information, or for that matter, criticism. So any of those things are welcome. Good luck, and we will continue on with the effort. And as I said, I will be doing some variation of this presentation in appropriate moments down the line. So hope you'll all rejoin for that. Thanks, everybody, and have a good week beyond it to the extent we all can.